Hi guys, it's Kathy. I hope you're doing well. I hope you're not here. I hope you're watching the Super Bowl, which I am not. But that's okay, because I really don't care if Pittsburgh's not in it, right? So, Bad Bunny's coming up. That's always good. We should break and watch Bad Bunny, but we don't have to. We're gonna watch Court instead. So the trial is coming up on this case. This is not the trial, okay? This is just a mess before the trial that they're trying to deal with. If we like it, then we're going to get this trial, all right? This teacher is in trouble. Here we go. We are in Indiana, definitely Indiana.
State of Indiana versus Julie Guthrie, 20-04-2406, CM 1046. I show State of Indiana appears by Deputy Prosecuting Attorneys and Chief Deputy Prosecuting Attorney. We have Attorney George Horn. We have Julie Guthrie here with us. We are set for pretrial conference. Before we get to the various motions, I do need to make a bit of a record after all on this. Prior to the start of today's hearing, there were juror questionnaires that were provided to both counsel. It was reported to the court that counsel for the defense provided the jury questionnaires to the defendant for review, who started taking with respect to the prospective jurors, their family members, where they work. This is strictly prohibited under the jury rules. It is at all times the onus on both the court and officers of the court to protect the sanctity and security of prospective jurors. It is strictly prohibited. I have met with counsel in chambers regarding this. Juror names and specific identifying factors are strictly prohibited. This is why we do a jury system with numbers and badges. Counsel has assured the court that it was just a simple error on the part of counsel and will not happen moving forward. State, do you wish to make any additional record?
No, Your Honor.
Mr. Horn, do you wish to make any additional record with respect to that?
Other than my apologies, no, Your Honor.
Thank you, sir. Let's turn now to the various motions that are filed in this manner. I have divided and organized all of them as such. I think it best to address these one at a time in order to make sure that we, number one, have an accurate record with respect to what is anticipated to be entered into evidence at trial and what would otherwise be excluded. I will note to everyone, as you all know, motions in limine are preliminary motions only. It is subject to the facts and circumstances as they are presented at trial. So any ruling the court makes today is a preliminary ruling. It really depends on what's going to happen at trial. That being said, I will do the best that I can, as well as counsel, to provide whatever facts and circumstances each side anticipates the evidence to show in order to get a good pathway moving forward. I would like first to start with the state's first motion in limine. And we can go from there. The state's first motion in limine was filed on August 11th of 2025. There are 7 requests. There was also a defendant's response to the state's motion in limine. Court has reviewed all of these. State's memorandum in support of both its first and second motion in limine. Ms. Hassan or Mr. Williams, I'm not sure who's taking the lead on these.
I'll be doing the arguments, Your Honor.
All right, wonderful. Ms. Hassan, whenever you're ready, let's start with state's first motion limiting.
Okay, thank you, Your Honor. Most of state's first motion limiting is pretty straightforward in its arguments. I guess some of the things we can just deal with initially based on defendant's response is section number 5, the letters. Those were noted in defendant's response that those will not be admitted into evidence, so we can bypass that, as well as number 7, which was also the DCS report, which was indicated would not be referenced to or admitted into evidence.
So, and I just want to make sure that you have a good record on this. So are you telling me that the defense is in agreement with the motion in limine with respect to number 5 and number 7?
That's my understanding from reading the defendant's response.
Mr. Horn, is that correct?
It is, Your Honor.
Okay, please continue.
As for state's motion limine, the bullet point number 1, we don't believe that any evidence related to the potential result that this conviction may have on the defendant
Thank you,
is
Monica. Thank
first
you.
relevant to the jury's determination of the charged offenses. Those are for the court's consideration as far as any sentence if there is a conviction. Second, if the court does find that there's some relevance or probative value in that evidence, we believe that it should still be not allowed due to Indiana Rule of Evidence 403 due to the substantial risk of unfair prejudice to the state. If the jurors were to learn of what could happen to Ms. Guthrie in a conviction in this case, they would be considering that instead of the facts of the case and what might happen to her. In this instance, we believe there would be a loss of her job or anything listed in defendant's response. So we believe that that would detract from the facts of the case and cause them to make a judgment based on sympathy or things that just aren't in front of their consideration for the charged offense.
Okay, I'm going to pause you right there. Mr. Horn, any response to that?
Yes, Your Honor. We believe the state attempts to undercut some of the most basic potential defenses, which goes to her motive. And that is, in this case, obviously, the state seeks to keep my client from being able to reference the fact that were she to be convicted, the collateral consequences would be enormous as a motive for her not committing any type of offense. Disincentive to, apparently, from what the state's going to say, shed a blind eye to what she may have thought or should have known was going on in her own household. Knowing the consequences, there's no way, at least from the defense standpoint, under the due process right to present a defense under the 5th and 14th Amendments that apply to this case, that she should be undercut from me being able to explain that those are certainly consequences which cut against any motive for her to close her eyes to anything going on in her house and allowing this to take place. Otherwise, the jury does not get they're left to speculate, I guess, to get a full and fair view of what would be a disincentive to my client to act in the manner the state's ascribing to her, given the potential things she would lose as a result of that. As a single mother of 5 children, providing a home, food, clothing to them, and in her teaching job of over 2 decades.
Great, thank you, sir. I am looking at both Bear versus State, which is found at 866 Northeast 2nd, 752. That's an Indiana Supreme Court decision from 2007. I also have another case. It's actually a fairly old case. DuBose versus State, 389 Northeast 2nd, 272, 1979. Both of those cases make fairly clear that potential sentence imposed would be both irrelevant to the defendant's guilt or innocence due to the fact that it's not an element or something the jury must consider, and specifically indicates that it is an improper consideration for the jury in the guilt phase. Mr. Horn, do you wish to address that?
Certainly, Your Honor, and my issue doesn't go to the potential sentence that
Okay,
the court would impose. It's the collateral consequences that would result therefrom, which is different than the cases apparently the court has cited to.
well, wouldn't that go to the very heart of the sentence, would be a potential collateral consequence, Mr. Horn?
Well, the court doesn't fire defendant from her job. The court doesn't potentially set her out on the street because she can't make her mortgage payments because she doesn't have a job. The court doesn't cause her to lose her licensure or cause her to lose the certifications that she has to do her job, or potentially subject her to a DCS investigation because she now maybe can't provide a home, clothing, or food for her children, and then subject her, to all of those collateral consequences. The court certainly, I agree that I can't say and subject her to potential jail time of up to a year and going to jail. I mean, she doesn't have a record, but certainly I understand that's in the scope of things a different animal, and the case law, I think you're right, is very clear in terms of that. This is different, though. We're talking about collateral consequences and disincentive to her given her circumstances, which I think are appropriate for the jury to know about and understand, obviously.
Ms. Hassan, any response to that?
Your Honor, the hardships argument that included in the state's motion in limine, again, that we believe is inadmissible due to 403 because the sympathy that is being invoked here it's going to lead the jury to consider all those hardships that she may face when determining their verdict, and we believe that is highly prejudicial to the state.
The standard is substantially more prejudicial than probative, not that it's highly prejudicial. And I don't believe the state or the evidence we're talking about would cross that threshold, Your Honor.
It absolutely crosses that threshold, and highly prejudicial is absolutely a valid argument, sir.
Just about everything the state is most likely going to present at the trial is going to have some sort of prejudicial effect. Where I can't get past is the relevance of it all, because I'm looking at what the elements are in the charging information, and I don't see how loss of a job or loss of whatever collateral consequences goes towards any element or makes one fact more or less of consequence. I don't know how we get past a relevancy standard on that, Mr. Horn.
Well, and with all due respect, Your Honor,
Sure.
I guess I will disagree with that because the things that we talked about go to those elements in terms of knowing and intentional. That's kind of the big element here.
So she's a teacher and a mother, and her son had weed, and now she is facing delinquency of a minor charge, and she might lose her job.
Is that my client engaged in this conduct knowingly and intentionally, so that she had a purpose. She did this knowing and intentionally, and as a result, her son, became a delinquent because of something she did. In the case law that we presented in our motion to dismiss shows that basically you have to engage in some sort of affirmative conduct, not sitting back, eating bonbons and not paying any attention, but you have to engage in some sort of conduct knowingly and intentionally encouraging, doing something that would contradict everything that her life has been and was at the time this incident occurred. So it is relevant because you have that knowingly and intentional element, which requires her conduct to be just that, not just something fly off in the night or she wasn't paying attention or something of that nature.
I am going to grant the state's motion in limine with respect to number 1 subject.
Imagine if we all lost our jobs every time one of our children did a drug.
Subject to the evidence as it is presented. Obviously, how evidence is presented and the questions that are posed are going to make a closer determination as to whether it is relevant to the elements of the charged offenses. But at this juncture, the court will grant the state's motion in limine with respect to number 1. With respect to number 2, any mention of criminal history of witnesses that are not properly offered. That seems to be a given to the court, Mr. Horn. Ms. Hassan,
So the defense is trying to do a bunch of sneaky, underhanded things here. And they're trying to get things in that are just not fair. They just got one thing in. There's more.
Anything additional on that?
No, Your Honor.
No,
Court will grant state's motion in limine with respect to number 2. Number 3, Ms. Hassan.
Thank you, Your Honor. As respect to number 3, the state would note that the defendant may present evidence of her good character through reputation or opinion testimony, but it must be offered for a pertinent character trait. The state does not believe that there is any pertinent character trait based on the discovery disclosed to us by defense and the witnesses that they could testify to a pertinent character trait that would be relevant to this offense. So we're asking that first, to be clear that any of that testimony be done through reputation or opinion testimony, and then 2, that there is no pertinent character trait at issue in this case.
Mr. Horn.
Your Honor, I think this is a case of kind of jumping the gun as a court reference. You know, seeing how the evidence come in, we have provided the state with a summary, an outline. The state has chosen to not take any depositions to know exactly what these witnesses will testify to in terms of reputation issues or whatnot. So I think this is an exercise in the state jumping a bit too far ahead of itself in this instance, in the court. I think it's best left to leave this denied without prejudice, to renew it depending on how evidence may come in during the course of trial.
All right, thank you. Court has reviewed relevant case law with respect to that. Again, I turn to Byrd versus State 593 Northeast 2nd 1183. That's an Indiana Supreme Court decision from 1992 that does talk about instances where evidence of good character may potentially be entered into evidence. That is going to be subject as to how that comes into play. I tend to agree, Mr. Horn. This is really going to be dependent on the evidence as it is presented, how it's presented, the manner in which it's presented, and how things flow. I am going to deny the state's motion in limine with respect to number 3. Number 4 seems to also be an extension of number 3. Counsel, would you agree with that, or do you wish to make separate argument?
That's correct, Your Honor. It's an extension of number 3.
I will also deny number 4, obviously subject to the renewal by either party. This is a preliminary ruling only. We've already granted number 5. Number 6, Ms. Hassan.
This is in reference to 2 photographs that were shared with the state as potential evidence and discovery in this case, and it is pictures. The first one, I believe, is a family picture of Miss Guthrie and her children, and the other one is an individual shot of one of Miss Guthrie's daughters, I believe. The state does not believe admitting these pictures.
They're trying. The defense team is trying to admit pictures of of her children. When they say that, look, if you find her guilty, this is who is going to suffer. These are the people who are going to suffer if you find her guilty.
Into evidence first is relevant because it does not have anything to do with the elements charged. And 2, if the court does find that it is relevant, the state believes that, again, under Indiana Rule 403, it would create an unfair prejudice to the state by luring the fact finder into making a verdict based on sympathy. We don't dispute that Ms. Guthrie or other witnesses can testify that she does have multiple children, but putting up pictures of them is not necessary. And the only purpose that can be is to cater to the sympathies of the jury.
Mr. Horn.
Thank you.
Your Honor, my client's family is not faceless. We're not putting up, if I ask the court to admit 20 pictures, maybe we got a good argument at that point. I'm asking for 2 pictures. The first photograph is a picture of the family at Henry's graduation. And it has several witnesses in it and my client's children, one of whom was missing, which is why we have the second photograph, which is her daughter, Tatiana. Those are the only 2 pictures. It's not an exercise in overdoing it. It's an exercise in
You can't do that, sir. That's not a defense.
putting a face to the names the jury's going to hear about. and it's 2 pictures, and that's all. It hardly meets the substantially prejudicial standard that's required under Rule 403. The defendant has a right to provide her story, if you would, and certainly there are bounds to that, but this in no way goes over those bounds. As I said, if we had 20 pictures, maybe we'd have a different argument. The court would be saying, Mr. Horn, pick your 3 or 4 best.
We'd be having a conversation in chambers real quick if you had 20 pictures, sir.
Understood, which is one of the things I was cognizant of in just providing 2.
All right.
Thank you, Your Honor.
At this time, court will deny stage motion in limine with respect to number.
She's gonna let these pictures in. This lawyer's gonna stand up and he's gonna say, look, if you find her guilty, these poor children are going to suffer so hard. What the hell?
6 as a preliminary motion. I haven't seen these pictures. Obviously, it will be subject to the evidence as it is presented as a preliminary motion. Number 7 is granted by agreement. That seems to incorporate all of the state's motion in limine. Ms. Hassan, is that correct?
That's correct, Your Honor.
Let's move now to the state's second motion in limine.
I can't believe he got
There
that
is
through.
the
That's
state's
crazy.
second motion in limine, a defendant's response to the state's second motion in limine that was filed. Ms. Hassan.
Thank you, Your Honor. The state's second motion in limine addresses concerns that the state had based on certain questions asked during depositions, where the witnesses were asked whether they had any evidence that the defendant is guilty of aiding the minor here in possession of marijuana. We're asking the court to grant this motion just to cut off that line of questioning because it's not permissible under the rules of evidence under the Indiana Rules of Evidence 704B, because asking the witnesses such a question, 1, is irrelevant because it does not assist the jury in understanding the case, because the jury is able to make those determinations on their own by looking at the evidence and determining what weight to give to each piece of evidence. Asking the witness their determination of that cuts into the jurisdiction of the jury. So we believe that asking those questions is inappropriate and inadmissible under Indiana law.
Mr. Horn.
Thank you, Your Honor. If I were to ask the jury or ask the witness, the ultimate question, that would be a different issue than the information that the state is attempting to get excluded. During the course of every law enforcement witness's deposition, we ask questions along the lines of the elements of the offense, which are not technical legal requirements. They're everyday language. Did you encourage? Did you assist? Did you find any evidence that she did those types of things? It's not a legal opinion that comes under the rubric of Rule 701, 702, 703, or 704. They're simply fact questions. Did you have any evidence that Julie Guthrie bought marijuana for Henry? That Julie Guthrie gave Henry had money to buy marijuana, going to the knowingly or intentional? We're entirely permitted to ask those questions. If I tried to ask, what evidence do you have that she's guilty? Maybe that's a little bit more of an issue. The questions we pose in the depositions are not. They're simple fact questions. Did you find any evidence that she in any way actively encouraged Henry to possess marijuana? Henry, go ahead and go buy marijuana. Here, have marijuana. Bring it back to the house and keep it here. Those are all entirely permissible to show whether she...
Wait, is he going to ask the witness, do you have any evidence that she did this? Is he going to say to the witness, do you have any evidence that she did this? Because that's not the witness's job. I mean, have you ever seen her provide marijuana to her son? That is an okay question. But do you have any evidence that she has given marijuana to her son? That's not...
knowingly or intentionally contributing to him being a delinquent. They don't go to the ultimate issue in this case, which maybe is not something that we could ask. They go to the very different specific elements, including the element of knowingly and intentional. And we're certainly permitted to ask those questions and challenge the state's evidence in that regard, Your Honor.
Thank you, Mr. Horn. I trust that counsel is well versed in the rules of evidence. There is a huge difference between asking the question of, did you ever see the defendant purchase marijuana for a minor, versus did the defendant contribute to the delinquency of the minor? I mean, that's the difference on whether it goes to the ultimate issue. Quite frankly, it sounds like, counsel, you both agree on this. You just disagree on what the potential question is. So for that reason, I'm going to grant the state's second motion in limine as a preliminary motion, subject to the evidence as it is presented at trial. Let's move now to the defendant's motion in limine. There was a defendant's motion in limine, the memorandum in support of defendant's motion in limine. Those were the two documents associated with this. Mr. Horn, what is it you'd like the court to know or consider?
Well, Your Honor, how would the court like to proceed? There are several different requests.
I want to take it through one step at a time so everyone's clear on A, what you're asking for, B, what the state's position is, and C, what the court's ruling is with respect to each one.
Okay, very good, Your Honor. Then with regard to the first request we make, that there are a number of requests. I believe there are 8 different ones that deal with the potential exhibits that the state has tendered to the defense and provided copies of to the court. Those exhibits we challenge are 11, 13, 14, 15, 19, 20, 22, and 24 as set forth in our motion and identified in our supporting memo. Would the court like to deal with them one at a time or go through all 8 of them?
Let's go one at a time.
Okay, thank you very much. State's Exhibit 11, which the court has a copy of, is a photograph allegedly taken in the minor's bedroom. We have filed with the court, both parties, stipulated order with regard to not presenting any evidence or any reference to gun-related evidence in this case. State's Exhibit 11 has a photograph in it of a package which is a gun cleaning kit, which would specifically be prohibited by the stipulations that have been entered into by the parties and presented to the court for ruling in this case. And those stipulations were presented months ago.
All right, thank you. State's response with respect to state's proposed Exhibit 11?
In State's Exhibit 11, it shows a view of a section of the minor's room. So there is a yellow box that I believe Mr. Horn is talking about. From State's Exhibit 11, you can't tell what that box is. There's no identifying marks to show that it's a pistol cleaning kit or a gun cleaning kit. So we believe it is admissible because it does not show what the item is. A juror wouldn't be able to see it and determine. The purpose of that photo is to give an overview of what that section of the room looks like.
Doesn't that violate your stipulation order?
Well, Your Honor, my understanding was that since you can't tell what it is, there's no firearm related evidence in that picture.
Is there a way to alter the or cover up that portion of the photo that would be in keeping with your stipulation?
Yeah, that is something the state would be willing to do and send a copy of the redacted photo over to counsel.
And I ask this question because while you may think that it's not something identifiable to anyone, inevitably there could potentially be a juror question asking that question, and now we're in some hot water because how do you answer that?
Understood, Your Honor.
That being said, does that satisfy you, Mr. Horn, if that portion is either removed, covered, or And it would have to be by agreement because now you're talking about a photograph that is not in its original condition. So that would have to be by agreement, sir.
Understood, Your Honor. We would certainly be willing to look at any redacted version of the photograph. And if that concern was alleviated, then I believe our objection would be taken care of at that point, Your Honor.
And Ms. Hassan, you indicated that that can be effectuated.
Yes, Your Honor.
I will grant state's proposed exhibit 11, noting that the state will be making adjustments to its proposed exhibit. This is a preliminary ruling only, subject to the evidence as it is presented in court. Let's move to 13.
So I don't know what the gun cleaning kit has to do with her delinquency of a minor, contributing to a delinquency of the minor. So I don't know if maybe it wasn't just her son had weed or her son was high. Maybe now her son had weed and was high and now has a gun. I don't know.
Mr. Horn, and I believe 13 is, well, I'll let you do that.
Same thing, Your Honor. In 13, we can see that it's a pistol cleaning kit because you can see the words.
Ms. Hassan?
Your Honor, the state can do the same thing, and it's in the corner, so it would be easily cropped out.
That was my thought as well, Ms. Hassan.
In addition to that, Your Honor, we also have the issue regarding the alleged grinders that are in that picture, which were not charged. Neither my client nor her son were ever charged with possession of drug paraphernalia. None of these items were subject to any scientific testing. And as the court knows, in Indiana, whether something is THC illegal or not is dependent upon meeting a 0.3% threshold. So we don't know whether these items, if indeed they contain any remnants of a green leafy substance, meets that threshold or not, because the state did not have them tested. And as a result, we don't believe they should be admitted into evidence because they're 404B bad acts that shouldn't come in general. And this court issued an order back in February of this year requiring the state to provide notice of intent to do that, and listed a number of things which they had to do, identifying the alleged crimes, wrongs, or acts, identifying the witnesses they intend to use to prove those, identifying the physical evidence, and identifying why they believe there's an exception to the rule that applies. The court order was very specific in that regard when it was issued, I believe it was February of last year.
Ms. Hassan?
Your Honor, the state does not believe that, first, in just addressing B through F together, that these items found in Henry Guthrie's room are intrinsic to the charged offense, that Ms. Guthrie was contributing to his delinquency. The evidence in 404B rule does not bar the admission of those acts when they're intrinsic to the charged offense, meaning they occurred at the same time or under the same circumstances as the crimes charged. Because such evidence happens near in time and place, and they complete the story of the crime and are admissible even if they tend to establish the commission of other crimes not included in among those being prosecuted. Some cases that discuss this, I would direct the court to Lee versus State 689 N.E.2D 435, decided by the Indiana Supreme Court in December 19th of 1997, as well as a newer appellate court case that addresses this issue as well. Jones versus State 250 N.E.3D 1062, decided by the appellate court in 2024. So we believe all of these items found in Henry Guthrie's room, first, most of them are not paraphernalia. They're not items used to ingest the substance, but they do assist the officer's investigation in determining where the tested marijuana was located. They give the jury an idea of what was in Henry Guthrie's room at the time of the offense, which is February 29, 2024. They were found all near in a small area of his room, and they are intrinsic to the charged elements of this case, that Miss Guthrie had knowledge of Henry's possession of marijuana on that date. We expect the officers to testify that such items are indicative of marijuana use, not because they've been tested for marijuana, but just because their training and experience leads them to know what those items are. So we believe that those items are admissible. They are not bad acts under 404B because they're intrinsic to the charged offense. Additionally, the defendant's been aware of all these items that the state intended to present at trial since receiving the police reports and as well as seeing all these items in person at the crime lab. So defendants had notice of these items. However, we don't believe that notice is required in this instance because they are so intrinsic to the charged elements of the offense. They're direct evidence of what the state is alleging in this case.
All right, thank you. Mr. Horn, you look like you want to say something, sir.
Oh, Your Honor, I think in a large way, Ms. Hassan makes my argument because while she claims they're intrinsic, they are the result of bad acts which should have been noticed. The fact that I saw a police report or the fact that I went to the crime lab and saw evidence doesn't mean it was going to be set for admission. In which case, I would still be entitled to know who, still be entitled to know what the attempt was to be proven by using these evidence.
Wait, and yeah, that too. Coke cans, soda cans, and roach clips I used to wear in my hair with the big feathers coming out of them. So, but if you see a grinder in his bedroom and he has a marijuana charge, yeah, that's admissible, sir. Why would that not be admissible?
Evidence. And the argument, I think tangentially without saying the words, is that these items are part of the race gesti of the offense. When Ms. Hassan says help show this, provide the rest of the story. And as the court knows, the race gesti theory went out the window 2 decades ago with the adoption of the Indiana rules of evidence, because the evidence has to comply with the rules, not with this big overarching race gesti theory, which was problematic on all sides of it. There are all sorts of different fronts. So this is kind of an effort to backdoor evidence in through the race gesti side of things, which no longer applies, and to avoid the Rule 404B order, which the court issued months ago and the defense and the state has known about and just simply didn't comply with in this case. And we also have the fact that my client hasn't been charged with anything related to paraphernalia. Her son wasn't charged with anything related to paraphernalia, and the state never bothered to test these items to determine whether or not they're paraphernalia, if they have any item,
Okay, first off, she doesn't have to test a grinder and she doesn't have to charge paraphernalia for drug paraphernalia to come in as evidence.
Of green leafy substance in them that meets the statutory requirement in order to be illegal THC under Indiana law. Moreover, as the state will no doubt say, these items, grinders are typically used to grind up substances so they can be ingested. So that is directly going to the evidence of Mr. Henry, if you would, Henry Guthrie, who's now an adult possessing marijuana when he was a minor. So the argument doesn't hold any water here, Your Honor, on several different levels. Thank you.
All right, thank you. So a grinder is not paraphernalia under Indiana law unless the state shows that it is specifically an instrument used to introduce marijuana into the body. And that's Granger versus State 113 Northeast 3rd 7073. Mr. Horn, you've already indicated that there are legal uses of some form based on certain percentages. So we can't always assume that paraphernalia is subject to illegality. Moreover, the identity of a particular substance is not an element of contributing. I want to make clear, folks, we need to stick to elements and not go down all sorts of rabbit holes here. To the extent that this is...
So a grinder is a rabbit hole? If he's charged with marijuana and there's a grinder, that's going down a rabbit hole?
Simply part of the case. I tend to agree with you on the res gestae of all of it, Mr. Horn. That being said, 404B does provide exceptions proving motive, opportunity, intent, preparation, plan, knowledge, and specifically that knowledge element is at issue here. And I would assume it is the heart of what we'll be talking about for the next 3 days. is whether Ms. Guthrie knew all of these items had been in her home. Unless I am on another planet, that's what I assume we're talking about for the next 3 days. To that extent, the rules of evidence make clear that the state can enter 404B if they provide reasonable notice of the general nature of any such evidence that the prosecutor intends to offer at trial. They are doing so. They have the filings that the court has reviewed all indicate that they have provided reasonable notice. We are here at a pretrial conference a week prior to trial. This is not, a anticipated exhibit or unanticipated exhibit, I should say, that would give rise to a trial by ambush. This is everyone's walking into this eyes wide open a week ahead of time as to what we're going through. So to the extent that states 13, 14, and 15, I believe also states proposed 19 also discusses the same. The court will deny the defendant's motion in limine for those proposed exhibits.
Okay, good.
Recognizing
Good job,
this
Judge.
is a preliminary ruling subject to the evidence as it is presented at trial. Let's talk about proposed 20, Mr. Horn. Actually, I'm sorry, strike that, sir. State's proposed 20 also discusses the same exact thing unless you tell me different, Mr. Horn.
It does, Your Honor.
Okay, so states 20, I am denying the motion in limine on that as a preliminary motion. Let's move to 22.
Okay. Your Honor, State's Exhibit 22 apparently is a full copy of Detective Wass's body cam video, which I'm unclear as to what the basis for providing that to the court is, since we're here about what evidence comes in at trial. It is replete with hearsay, all sorts of inadmissible items, which is part and parcel of why the state, I think, has condensed the videos into a 15-minute video of the search and then a 3-minute and 15, I think, second video of the check of the house prior to the search. So I see no reason. There are so many different issues with this video.
See that, man? Imagine that. Imagine you lose your job if your child is a nurse and has hemostats.
And the fact that it's not being submitted apparently for evidence. I don't see any relevance to it at all. It's 401, 403. Certainly shouldn't be part of the court file in this case if it's not going to be used as evidence at trial.
Mrs. Sun.
Your Honor, the state identified a potential exhibit 22 just based on, I know different courts have different perspectives on when a video is clipped down, whether the full video needs to be a part of the court's record or if just the clipped down versions need to be a part of the court's record. State doesn't intend to publish any portion of State's Exhibit 22, but it is the full video of clips that come from State's Exhibit 23 and 24, or 20, the two clips that come from that video. So we would leave it up to the court if they want a full copy of the video or not, just based on the court's preference.
I like to do what the law says. And the law says you can enter in a redacted video unless Mr. Horn objects under doctrine of completeness to say that, hey, look, we need to have the entire video. And if that's the case, then we talk about how that's going to work and whether that gets published, et cetera, et cetera. I have multiple instances where redacted videos are entered into evidence, and that is the evidence in the case. I'll leave that up to you, Mrs. On how you best want to do that, because I haven't seen the video, so I don't know what's on the video. But if you're telling me there's inadmissible hearsay on it, obviously that's going to be excluded. Or if there's other problematic things, we'll have to talk about it as we get there. I can't imagine a jury's going to be interested in watching a half hour of dead time from an officer's body cam, but I'll leave that to your discretion as well.
We do that every day, all day long. Half hour dead time.
Mr. Horn, anything further on that one?
No, Your Honor.
I will grant the defendant's motion in limine with respect to state's proposed exhibit 22, noting that the state will perhaps be entering into evidence a redacted version of the video, and that may in fact be admissible and or published to the jury if that is requested. At this point, I'm not sure what the value or relevance would be of having the entire video, but again, this is a preliminary ruling subject to the evidence and objections made at trial. So I will grant G. Let's move to H, which is state's exhibit 24.
Thank you, Your Honor. State's proposed exhibit 24, although, and I don't know if the state's copy has it marked, wasn't marked on mine, but I believe is the order, the disposition order from the minor's hearing, actually before Your Honor, in juvenile court. And that order, as we've pointed out, has a number of inaccuracies in it. Ms. Becker and I, a long time ago, identified that issue and talked about perhaps requesting that the order be amended to reflect the accuracy of what happened at that hearing back in May of 2024. That was never followed up on. And frankly, we have provided a stipulation to the state regarding that particular issue to avoid having to delve too deeply into issues regarding the accuracy of the order. Save it to say, whether it's certified or not, if the order is not accurate, it can't come into evidence. I don't know that the state objects to that. We did, as I said last week, provide a copy of a proposed stipulation. I haven't heard back yet whether that stipulation will satisfy the state so that we can avoid having to argue about an issue which has, or an order which has a number of inaccuracies in it, which is clearly not admissible.
Mr. Horn, I have to ask, what are the inaccuracies that you see in the order?
We've listed them in our motion here. I'm trying not to go through all of them.
Okay, let me get the state's position on this first.
Your Honor, as one of the charged elements in this case is the state has to prove that HG was adjudicated as a delinquent, so we are offering the certified copy of the court's order that he was adjudicated as far as the possession of marijuana offense. That's the purpose and relevance of State's Exhibit 24. We did redact.
And if you're going to be charged with contributing to delinquency of a minor, then yeah, that's relevant.
Portions that allude to the criminal recklessness charge in this, and provided a copy to Mr. Horn. If there's other things that need to be redacted outside of the actual adjudication, the state would be happy to work with Mr. Horn on that. But we do believe that to meet one of the elements of the offense, we do need to provide a copy of the certified court order of his adjudication.
I haven't heard a response to the stipulation we provided, which stipulated that on or about, I believe it was May 10th of 2024, that HG did make an admission in juvenile court to possession of marijuana, which, had he been an adult at the time, would have been a Class A misdemeanor. Which would be misdemeanor, sorry, which would alleviate all of the issues. The redacted order, in addition to looking redacted, has a number of things in it. It mentions felony in it under adjudication. It, shows HG being in juvenile detention, which is inappropriate. Talks about him remaining outside of the home and in the care of his grandfather, which would be inappropriate, would go to sentencing. It has nothing to do with this case, which would be 403, irrelevant and inappropriate. It talks about a petition for parental participation, which never actually occurred during the disposition hearing. It references the felony, talks about the minor signing an advisement of rights at the disposition hearing, which did not happen. Talks about possession of marijuana as count 2, when in fact it was count 3. Mentioning the additional count is improper, or mentioning the count number is improper because it confers to the jury that he was actually charged with more than one offense. we'd end up with a chopped up, I don't know what to call it, if we were to go through the order and do that, as opposed to the stipulation we provided to the state, which addresses the issues that they, and I understand it needs to be put before the jury, and we stipulate, that's why we provided it to him, that he did enter that admission. It would be, it would be a misdemeanor if he was an adult to possession of marijuana. I don't know why we're having this discussion at this point, given the stipulation we provided.
If you guys want to stipulate that, I most certainly don't have a problem with it. The petition, just so you know, Mr. Horn, the petition for parental participation is a document that gets filed in juvenile court at the very beginning when a case is first opened. It's not a separate hearing that gets held, just so you know. That being said, obviously the order does have some concerns in violating the other stipulation with respect to references of the criminal recklessness as a felony and the deadly weapon part of that. So that would need to be redacted. Why don't I do this, folks? It sounds like you both are still a little bit in negotiations on that. I'm going to take H, Stage Proposed Exhibit 24 under advisement. You most certainly can address it the morning of trial. Again, these are motions in limine, but I'll take this one under advisement. I trust perhaps this will be a non-issue moving forward when we start the trial, but we can go from there. Let's move to untested items under number 2. Mr. Horn, do you wish to be heard on that?
Just briefly, Your Honor, the court has our argument in the motion and that we set out in the memo in support. Again, going to the 404B issue, 403, and the fact that none of these things have been tested, so we don't know whether they're illegal or not. If they have any residue in them, whether that residue is above the threshold required for them to be illegal in the state of Indiana, and the state didn't test them. And that's on the state. It's not on us, and it's not on, effectively what that would be admitting speculation about what those items contain and whether they're illegal or not. And that would be speculation that certainly would not inure to the benefit of my client. Thank you.
Thank you. And if I understand number 2, number 3, and number 4 correctly, they all really go to the arguments that counsel has both made with respect to states 13, 14, 15,
I'm sorry.
19.
But part of his argument did he just say out loud in court that part of his argument is this evidence isn't to the benefit of my client? Is that what he just said? That's what he just said, because I was listening intently.
15 and 20, is that correct?
That's correct, Your Honor.
That's my understanding as well. Okay. So court does take numbers 2, 3, and 4 as a further fleshing out of the arguments that the court has already ruled on. Again, noting that identity of a particular substance is not an element of contributing to the extent that the items photographed or intended to enter into evidence constitute bad acts, which may or may not be the case. I don't know yet. It perhaps would go towards knowledge in this instance, which would be an element of the offense, and thus perhaps may be admissible under 404B, and notice has been reasonably given under B2. Let's turn now to number 5, because that does raise a separate issue. Mr. Horn.
Yes, Your Honor. In the depositions of police witnesses, we had several who said they didn't smell marijuana in the house on the morning of February 29th of 2024 when the police were there. We had, as I recall, 2 who said they did. There's a lot of back and forth. We had 2 witnesses, I believe, who said that because they've been around marijuana so much, there's this very theory out there that your sense of smell to marijuana, your olfactory senses are somehow dulled to the odor of marijuana. And therefore, it doesn't mean they wasn't there. It just means you weren't able to smell it because of that. Certainly, that appears to be evidence that deals with scientific issues related to olfactory senses, and none of the witnesses are qualified to make that determination or opine in any size, shape, or form on that type of level based on education.
I think he's a teenager because he was adjudicated. He got arrested for this. And I don't think they arrest 9-year-olds for weed.
Based on training, based on any peer review articles, based on any of the...
He has a gun cleaning kit in his room beside his grinder. So I'm definitely a teenager.
Dalbert factors, or Dalbert, depending on where you're from geographically in the United States. My brethren in the South would say Dalbert. Up here, I think we say Dalbert generally. But based on the Dalbert versus Dow Pharmaceuticals case, which has been adopted by the Indiana Supreme Court, they don't meet any of the standards for admitting that type of expert opinion in this case. And therefore, it should not be admitted in any size, shape, or form. Or, for instance, I think there was one reference to try and explain why maybe Sergeant Aylersmeyer, who was in the house he was the first officer on the scene, a body cam, an hour and 47 minutes, never mentioned marijuana, was very definitive. I know the smell. I never smelled any in the house. So my worry is someone's going to try to say, well, because of this phenomena, he's been involved in a number of marijuana cases. He probably couldn't smell it because of that. And that certainly wouldn't be appropriate in this case.
I want to make sure I'm understanding your argument. Is there an anticipation that an officer is going to get on the stand and say, I couldn't smell marijuana in the home? And then a second person's going to get on the stand and say, that officer couldn't smell marijuana because of their medical diagnosis?
No, because of this, we call it the so-called inability to smell marijuana argument, because of having been exposed to it so frequently. That's the concern.
But it's not their own personal perception.
Maybe the lawyer has been sampling the evidence, and that's why he's saying some of the things that he's saying.
That's correct.
They're opining on someone else's senses.
He should start giggling a little bit when he says some of this stuff.
That's the concern. They have no foundational basis scientifically to say, for instance, that Sergeant Aylersmeyer probably couldn't smell marijuana because he's been involved in 100 cases or more related to marijuana over his 20-year career. There's no scientific basis under the rules of evidence, under Dalbert, for any of them to do that. Someone may, for instance, say, my senses personally have been dulled to it, I suppose. Their personal experience, that's lay opinion. As to themselves, that's an entirely different issue. But they certainly have presented the state no one with sufficient background to make an olfactory type of opinion with regard to anybody else's ability to smell one way or the other.
Mrs. Hahn?
Just to be clear, we do expect some of our witnesses to testify that they did not observe the odor of marijuana in the house. And if they were pressed further on that issue, we expect their testimony to be, well, in my personal experience, I have become nose dead to the smell because I encounter it so often, as in their training experience.
They're talking about themselves, though.
Yes,
they're not talking about somebody else.
That is my understanding. I
trying to differentiate between witness perception, their own personal perceptions, and someone else opining as to a medical diagnosis, because that's two very different standards.
Yes, Your Honor. The state does not intend to present any evidence of a other witness commenting on one witness's perception of the scent. There were some questions by defense counsel during the depositions to a certain witness. Would they be surprised if this witness did not observe the odor of marijuana? But I think if defense asks that question, they're opening the door to that witness's answer. And we're not intending to ask any questions asking a witness to opine on the senses of another witness. We will strictly ask questions based on their personal observations.
We have about 40 more questions if either side rolls a doctor in here to start testifying as to somebody's potential smell or non-smell of something in this juncture. I think it would be rationally based on a witness's perception if they themselves can or cannot smell something. That's a perception. That's perfectly allowable under the rules. What's not perhaps allowable is if Joe says that, well, Sally can't smell it because Sally has a medical condition. If Joe's not a doctor and hasn't diagnosed Sally with anything, we've got a problem. Does that clear up this issue, Mr. Horn?
I think it does, Your
We're all
Honor.
doctors
Okay.
here. We will let you
So,
know.
in this instance, I don't even know how to address this.
I think the court would say that the witnesses are allowed to testify about their own perceptions and their own experiences, but not as to other witnesses.
Jen, thank you for the PayPal. I appreciate it. Thank you.
But I think that's
Unless-
the case in any situation.
Right, unless they present sufficient qualifications, and we don't have those here.
All right. Anything further on that, Mrs. Hahn?
No, Your Honor.
Okay. So the court will clarify with respect to number 5 that 701 allows witnesses to testify rationally based on their perceptions and are allowed to do so. Any evidence that would require a medical diagnosis and or opining as to the medical diagnosis of another individual will be subject to 702 and 703 requirements. Let's move to Oaklawn records, Mr. Horn.
Thank you, Your Honor. As the court's aware from the information we provided on March 1st of 2024, Ms. Guthrie executed a release of her sons, then minor sons, Oaklawn records to Elkhart juvenile probation only. And those records had to do with substance abuse related issues. She did not at any point exercise release of those records to the prosecutor's office or to any other law enforcement related entity. It appears that, not it appears, in December of this year, as we indicated, we were provided a copy of those records by the state, which apparently had been provided by Oaklawn to Ron Vivian, Elkhart juvenile probation. He in turn turned them over to the state without any authorization from my client. That is a violation both of HIPAA because it's substance abuse records, while HIPAA allows redistribution of records from a release under certain mental health circumstances, it does not allow under substance abuse circumstances. Further, while, as we've provided the court the law on, while HIPAA does allow those redistribution of records in certain circumstances, it gives way to any state laws which are more restrictive. And Indiana law is more restrictive than the federal law and does not provide any avenue for redistribution of those records. In this case, what Mr. Vivian did by providing the records to the state was illegal and was not allowed by the release that he was provided. And as such, the state should not be able to make any use of those records, any mention of those records, or any mention of any of the information contained in those records as part of this trial at any point in time because they were improperly conveyed to the state by Mr. Vivian in violation of the release, in violation of HIPAA regulations regarding redistribution of the records, and in violation of Indiana law, which is not allowed for the redistribution of those records where there was no specific release to the state, to the prosecutor's office provided by my client.
All right, before she responds to that mess that he just gave to the judge, you cannot buy the clove cigarettes anymore. You can buy clove cigarettes, but you cannot buy clove cigarettes that they had back in the 80s. I looked it up because John said something about the smoke pills that smelled like pot. And if you've never smoked a clove cigarette before, it does not smell like pot, but it does smell very strongly a very strong smell.
Great, thank you, sir.
Thank you.
And again, I'm trying not to go down a rabbit hole here. I can't figure out why Oakland records would be relevant in this case. Mrs. Song.
Your Honor, these records were sent to Mr. Horn on December 9th, 2025. They were specified in the email that there's no intention to introduce these records as evidence. However, if should Ms. Guthrie or Henry Guthrie testify to something different than what we know from these records, then the state would ask them questions relating to their knowledge.
I'm not going to allow the mental health records of a minor be entered into evidence for a whole slew of reasons. Most importantly, I can't think of an instance where that would be relevant. I am going to grant the defendant's motion in limine with respect to number 6. Let's move to, I think 7 and 8, Mr. Horn, are kind of one and the same, sir, or do you want to splice them out?
No, Your Honor, I think 7, 8, and 9 are
And 9.
pretty easy, actually. I don't think the state may not object to those in any event. They're certainly pretty easy, all constitutional rights of the client. And certainly the state would be inviting a mistrial if they raise the issue, unless for some reason the door was open to them.
Mrs. Hunt.
Your Honor, the state does not intend to comment on those refusals or rights.
I will grant 7, 8, and 9. About number 10.
And this, I'm not sure if the state even intends to address this evidence, but the state has listed Ms. Ebeling as a witness in this case. As the court knows, she was a probation officer after she left the juvenile court employment and had some involvement with my client and her minor son before probation was formally transferred over to St. Joe County, where it was finalized and successfully completed. I don't see anything about that probation history that's relevant in any size, shape, or form, which would allow it to be admitted into evidence in this case. And certainly doesn't meet the 401 requirements for relevancy, 402 requirements related to same, Your Honor.
Mrs. Hunt.
Your Honor, combining them together, the state does intend to have Ms. Ebeling testify as a witness more to some definitions in the charging information as what the juvenile court is, what an adjudication is, what a delinquency is, as to help the jurors understand what those words mean in the charges. And if there is no stipulation, we would use her as a witness to admit the adjudication that she is familiar with Henry Guthrie, that these are his court records, his date of birth, the things that we need to identify that this adjudication relates to this individual. So we do believe it's relevant in having her testify for that purpose.
So, as you both know, Ms. Ebeling was a employee of the court before she was a probation officer. So that obviously has some muddying of water there with respect to Ms. Ebeling both preparing orders and then in her new role being the supervisory probation officer for that. Again, I'm not quite sure how relevant her testimony would be. The court provides the jury with final instructions, preliminary instructions on what the law is, and the court's instructions are the best source in determining the law. If my memory serves me correctly, and this is no disrespect to Ms. Ebeling at all, I am fairly certain she does not have a law degree or has a particular expertise in the area of law. So I'll leave that up to counsel how you want to proceed with that. But the court's instructions are the best source in determining the law, and the court most certainly can provide the jury with definitions with respect to what is an adjudication, what is a delinquent, how is that defined under the law. Unless there is some sort of probative value outside of Ms. Ebling simply providing legal definitions, I'm not sure that's going to be allowable, Ms. Hassan.
Well, Your Honor, the state would also use Ms. Ebling to admit the certified court and identifying.
That makes more sense. If the certified court order comes in and it's not by stipulation, it has to be entered in through some sort of witness if there's no stipulation on that. Mr. Horn?
Again, as the court knows, that would be a bridge to cross when we see what the document is that is ultimately being proposed for admission. So that's the hurdle we probably won't get to her on anyhow. And then at that point, if we don't have a stipulation, then we would request that the court simply provide the information to the jury by way of an instruction of some type fashioned by the court, perhaps in conjunction with the parties, because the testimony is going to be confusing. It's going to be, to some degree, I'm concerned, irrelevant, and we're going to present all sorts of issues we can avoid very easily by simply coming together with a stipulation, especially in light of the court's reluctance to have Ms. Ebling testify on other areas.
It's really going to come down to, folks, whether there's a stipulation on the delinquency adjudication that is at play, or if the court order needs to be entered into evidence for the jury to consider. If the court order needs to be entered into evidence, you're going to have a witness presented in order to enter that document. Me taking judicial notice of it does no good for a jury. You still have to have the document.
Well, and it's not something, with all due respect, we have a certification that is problematic at this point in time, I think.
If you both stipulate to something, it becomes a non-issue, and I don't know that there's a
purpose in providing, we've provided the stipulation to the state for, Your Honor.
Anything further on that, Ms. Hassan?
No, Your Honor.
Okay, and is it the state's intention to get into the, I'm going to say minor, he's not minor anymore, but at the time, minor, the minor's probation
There we go. He was probably 17.
history?
No, Your Honor.
Okay, so we don't need to talk about that. I will grant number 10 then as a preliminary motion subject to the evidence as it is presented. I believe that also incorporates number 11, which I will also grant. Gun-related stipulations, these are stipulations, so
They've already been submitted to the court.
you guys have already submitted those. We are done with that. Separation of witnesses under number 13. I do that as a matter of course, Mr. Horn. If one side requests it, I order it. Just so you know, so that will be a non-issue. With respect to defendant's motion in limine, is there anything further we need to address?
I don't think so, Your Honor. Thank you.
What a great,
Let's move now to
That was a great use of the court's time. That was great. They got a lot done.
defendant's motion to exclude attorney-client communication. Mr. Horn.
Thank you, Your Honor. As the motion and the memorandum set out, my client was in her home with Sergeant Aylersmeyer early in the morning of February 29, 2024. She and other members of the household were in the living room and basically being told they had to stay there. At a point in time, the sergeant asked about a consent to search a white Jeep that was at the premises. My client asked for the opportunity to call her sister, who is an attorney in the state of Florida, was a former prosecutor in Indiana before she moved to Florida.
Ooh.
And apparently during the course of that conversation, some of the conversation was overheard, not with my client's intent that it be overheard, by Sergeant Aylersmeyer, and the state apparently intends to seek introduction of that during the course of the trial in this case. That statement is not contained in Sergeant Aylersmeyer's report, but was brought up in Ms. Hassan's questioning of Sergeant Aylersmeyer during his deposition, after he had said that we talked about everything that was important to him in the investigation. And she came in and asked a question about the statement involving the vape, where there may be a vape of some unknown kind, whether that's nicotine, whether it's THC, whether it's who knows what. He apparently was in position to overhear part of that discussion, and the state intends to try and introduce that, which we believe violates the attorney-client privilege. My client wasn't in a position with the opportunity to go outside or the opportunity to go into another room. She was in a place where she was being confined at the time this happened, and the sergeant overheard that and was in a position to, or put himself in position to. I don't know which that was, but certainly the attorney-client privilege is in violate. My client did not waive that, despite the response of the state that she somehow engaged in the conversation in a manner that he was able to overhear. She could not move.
I don't know. Okay. On one hand, there's attorney-client privilege, so the defendant can't. You can't ask the defendant about anything that's attorney-client privilege. That what they speak about, what she speaks about with her lawyer. But if an officer is doing an investigation and he overhears a conversation, then she waived her right to attorney-client privilege. Like if you and your attorney had some emails going back and forth and you publish those emails on Facebook, you have waived your right to attorney-client privilege at that point, and that those emails are admissible. So let's see what the judge says. I don't know.
So there was no voluntariness on her part in terms of waiving the privilege. She had to talk to her lawyer, and he was in a position, or put himself in a position, to overhear it, and that certainly isn't permissible.
All right, thank you. This seems to me to be fairly fact specific, because I think the law really comes down on the close proximity, the availability to get to a space where it's clear that a privileged communication will be occurring. Anyone who's ever had a private practice knows that once you bring a third party into the mix, attorney-client is compromised. So this does seem to be fairly fact specific. Ms. Hassan?
Thank you, Your Honor. We believe that the facts indicate that Ms. Guthrie had this conversation in full view of Sergeant Ehlersmeyer. He, as we outlined in our response, this happened in the living room of Ms. Guthrie's home. Ms. Guthrie asked Sergeant Ehlersmeyer if she could make a phone call, and he said, sure. In the room at that time was also Henry Guthrie. Prior to this conversation, Ms. Guthrie is seen moving throughout the house, and she could have moved to a different room in the house to have this conversation. During the conversation, she is also talking to Sergeant Ehlersmeyer, so we believe that further indicates that she was willingly having this phone call with her sister,
That's not
knowing
privilege.
that Sergeant Ehlersmeyer could observe it. And I agree, it is very fact specific, because there's portions of the conversation that the state intends to admit that happened just between Sergeant Ehlersmeyer and Ms. Guthrie. Then the phone call is made, there's portions during the phone call, and then there's further questions to Sergeant Ehlersmeyer while she is still on the phone. So based on the case law, we do believe that this is not subject to attorney-client privilege, because this was not a confidential phone call. And we believe the case law is clear that it's on the defendant to safeguard her conversation and make sure that no third parties are overhearing. In this case, there were two third parties that overheard both Henry Guthrie, which if he was able to remember these statements, he was in clear earshot of those statements, as well as Sergeant Ehlersmeyer. So we believe that there's no privileged communication here.
All right, thank you. This one, counsel, might need to happen outside the presence of the jury when we get to this moment, because there's two questions that I need to have answers to, and it's, where did the communication exactly take place? Was it within close proximity of other individuals, and where there was a clear intention of other individuals to potentially be able to hear this conversation? And did the defendant safeguard the confidentiality of the communication? Those are the standards the court needs to look at. It's a question of whether that confidentiality was in fact waived by the other persons present. I don't know the answer to that because I don't have the facts yet. So this may be one we've got to take up outside.
It was waived. The state just told you it was waived.
The presence of the jury, when we get to that point in trial, are you both okay if we do that?
I think that'll be the preferred way to handle it.
Okay, Mr. Son, does that work for you?
That's fine with the state, Your Honor.
All right, court will table the motion to exclude attorney-client communication until we cross that point during the trial. Finally, let's go to defendant's objection to and motion to exclude video evidence at trial. Mr. Horn.
Thank you, Your Honor. As the court knows from the motions, and I'll start with the 15-minute motion, we'll call it the long motion. Or the long video, I'm sorry. That video, as we have indicated, contains a lot of hearsay. As it was presented to us by Ms. Hassan, the volume was not turned off. It wasn't muted. So there are hearsay statements throughout in terms of what the officers see, what do you smell, smells like weed, all sorts of things which wouldn't come into evidence in the trial. There also are observations of the box, the yellow box, which the court has already indicated should not be part of evidence. And
so I know his main defense of his client is she's innocent because if she would have done this, she would lose her job. That's his main line of defense. But what I don't understand is why he keeps bringing up the smell of marijuana or things like that, because the kid was found guilty of one count. He was charged with 3, found guilty of 1 count of drugs, and I think there was a gun involved. So it doesn't really matter if anybody smelled it or didn't smell it, if it was tested or didn't tested. Her child was charged with this and found guilty. And she's a teacher. So, you know, the state is saying that she contributed to the delinquency of a minor. I don't know why he keeps bringing in all this other stuff, because it doesn't matter. He can't say it didn't happen if that's what he's trying to do. Like it never happened because he was found guilty already, or took a plea deal.
the video at the end goes into the room where the firearm was eventually found, which obviously by stipulation can't come into evidence. So there are lots of issues with the video. I know Ms. Hassan is continuing to kind of develop redaction of the video. I'm not quite sure where we are on that yet, but at this point in time, to do it in a timely manner, we felt compelled to file the motion as we continue to kind of move through this redaction process to perhaps a point where we can agree to the video. But at this point, we haven't reached that juncture in the video as presented. Is clearly not admissible because of the factors that we've identified in here and that we provided to the court in our memorandum. And by that, I mean the 15-minute video, which involves the search of the house. And if the court prefers, I think we do these one at a time.
Okay.
Thank you.
With respect to the longer video, it sounds like this is still a work in progress. Is that correct?
Your Honor, the state's intention that we indicated to Mr. Horn is that we are not going to play any sound on this video. We were going to play it mute for the jury because we can see there's hearsay evidence with the officers talking through the search. From my review of the video, I was careful to cut out any locating firearms or things like that or officers drawing attention to such material. And it does clip off before, I think the end of the video is you see an officer walking towards where they eventually locate the firearm. But excuse me if I'm mistaken, there is no visible locating of a firearm. It's just kind of the commencement of the search in the drug-related issue. Again, I don't necessarily know if it matters what we show, but if counsel's more comfortable with it, I can end it before then and send a copy over.
All right. This also seems like one that is a bit a work in progress. So I will withhold ruling on a motion to exclude until we've got a final version of what will be subjected and potentially offered as evidence at trial. Let's go to the second issue on that.
The second video, Your Honor, is what I refer to as the clearing video, which is about 3 minutes and 37 minutes, 3 minutes and 37 seconds in length. It's sort of a process video. I think the state moves to admit it because it shows the officers going through the house to clear the house, basically, to make sure there's no one else in there or anything that would inhibit their ability to conduct a search. It is gratuitous in many respects along those lines. Basically, we've got a bunch of officers in uniform with guns that heighten the issue of what the police were there for, even though all we're talking about is a baggie of marijuana less than an ounce, less than a gram actually, in weight. So it becomes highly prejudicial, substantially more prejudicial than probative, because any officer can testify to, this is what we did. And our standard operating procedure is to clear the house. And we did that. And basically they'll say, we didn't find anybody in there or anyone else in there after we had removed the residents from the house. Easy. The video, however, provides a whole lot of prejudicial impact with uniform officers with guns going through the house. There's hearsay in the video. It's irrelevant, basically, to the issue. There's not a question about whether the police conducted the search. There's not a question about whether there was anyone in the house at the time they did. There wasn't. Everyone concedes that. There's no question about it. So the video is inappropriate for hearsay. It's prejudicial. It's irrelevant. It's substantially more prejudicial than probative. And by its very nature, it conveys to the jury a sense that this was a much more serious and dangerous situation than it was based on the charge.
So this is not relevant. The police searching the house is not relevant. But whether someone can smell marijuana is relevant, right?
That they're here to decide. And that adds a level of prejudice which puts it outside the realm of admissibility in this case, Your Honor.
This is something.
Your Honor, the state does not.
The video shows what is seen in the house. So she can prove the mother knew or did not know about this. Because if it's in the living room, on the table, in front of the television, in front of the couch, in front of the television, yeah, she contributed to the delinquency of a minor. It's a school teacher who has a child who got busted for marijuana. So now she's about to lose her job and she's being charged with contributing to the delinquency of a minor who was like 17 at the time. I don't know. I feel so bad for her because at 17 you're uncontrollable. Their frontal cortex is not developed. They have the stupidest ideas ever, and they do whatever they want to do, and they don't listen to you at all. So now she might be losing her job because her son did this. Oh, wow.
I believe that it is, the video itself is unfairly or substantially unfairly prejudicial. It's not going to be a secret that there were at least 4 officers at the residence that day, that there was a search warrant conducted at the residence this day. Again, by stipulation, we don't believe that the firearm related evidence is admissible, but from the state's perspective, it is going to be clear that officers were conducting an investigation at the residence and that there was a search warrant conducted for the residence, and that's why they were there. The officers moving through the house gives the state the layout of the house and a visual perspective of what the house looked like, whose rooms were where, and just a visual observation of the movement of the persons between the house, just showing the separation and use of different family members in the house. We believe that it is relevant to the state's case, showing that as opposed to just having officers who have only been to the house once to testify to the layout and the dimensions of the house, instead showing exactly where each room is located through that video. There is a statement at the end that the state, of Detective Newman, that the state believes that it will be able to lay the appropriate hearsay foundation through Detective Was for, but obviously we can't have the foundation laid without his testimony. So the state believes that that 3-minute video is both relevant and admissible.
All right, thank you. at this juncture, the state has at least established a baseline of relevancy on this with respect to prejudicial effect. It sounds to me like there's going to be testimony of officers, so a video of officers is not going to shock the conscience of any of the jurors in listening to the evidence. I will deny the motion to exclude the video of the pre-search clearing of the Guthrie home, again, as a preliminary motion, subject to the evidence as it is presented. Mr. Horn, if there is something in that video that is particularly objectionable, because remember, I have not seen the video.
Well, I brought copies, Judge.
Okay, if you would like the court to review evidence ahead of time in the interest of time, I'm happy to do that.
Your Honor, if I could, a couple of things. One, with regard to the argument that it shows the layout of the house. The state has numerous photographs of this house if they wanted to use those. We have provided Defense Exhibit 3 and C and D, which are diagrams of the house, which lay out the rooms of the house, both on the first floor and in the basement. They lay them out accurately. They're not to scale. How much is to scale these days? But the state's witnesses in deposition have confirmed that these diagrams do accurately lay out the floor plan of the house. So the jury will have that. My concern, aside from what we said, while they may know officers are there, perception becomes reality. And the perception is this is a huge investigation where you have a lot of officers in guns running around this house. That well outpaces a misdemeanor charge that's brought here, so that the prejudice may be inferred by this jury because of those number of people and the gun situation. And also the statement gratuitously made now by Detective Newman, which is the first time I've been told who made that statement here a week before trial. Didn't know who that was before then, or who might be in a position to try and identify the voice and say who it was. The statement was made gratuitously hours after everybody was left from the house. Therefore, it's not relevant to show what anyone knew at the time they were in the house early in the morning of February 29th of 2024. So it's irrelevant. It's not timely for that matter and should be excluded, in addition to the fact that it is hearsay.
Right, thank you, sir. I'm not sure at this juncture that changes my position on the motion to exclude the pre-search clearing of the home at this time. Again, it's a preliminary ruling. Mr. Horn, if you would like me to view the video prior to trial to take a closer look, perhaps there's something on there that I'm sure there's something on there I don't know. And I'm happy to revisit this issue should something arise that we need to take another look at and have another conversation about it.
And with these are put them on a flash drive.
Thank you for
Any
the
objection
PayPal.
from?
And
I'm asking if there's an
gift
objection. I'm sorry.
Thank you.
I propose to provide the court with
Jen,
copies of
thank
both
you.
videos, which I have put on a flash drive and brought with me here today.
Well, it would be, you're not entering the evidence, Mr. Horn. I believe it would be something the state would be admitting. Do you know on those flash drives if that's what you're potentially going to be admitting? I don't want to review evidence that's not
Yeah, I think, Your Honor, the burden, I brought the motion.
correct.
And the law, I think, requires where we don't have agreement and we're still in flux on that, the court would have to review the video. So I think it's probably on me to provide that to the court.
Do you have any issue with that, Ms. Hassan?
I guess the only record I would make, I did send those clips digitally to Mr. Horn, and it's clear we've reviewed the same thing. So I don't
That's all I
know
wanted to
exactly
know.
what's on there,
Understood.
but
All right, come on up, Mr. Horn. I just wanted to make sure I wasn't watching two different videos.
No, ma'am.
All right, thank you.
You're welcome.
Okay, I believe that takes care of the motion to exclude video evidence at trial. Were there any other motions preliminarily we needed to address today? That was my stack, counsel.
Understood. I think we've covered them all.
there's no other motions from the state's perspective, and I would ask, it might be better to address the proposed jury instructions the morning of.
Yeah, we're not gonna do that today. Okay, let's go to the general part of a pretrial conference. Is discovery complete from the state's perspective?
Yes, Your Honor.
Mr. Ward, is discovery complete from your perspective?
I would say yes, with the possible exception of the gratuitous statement I made reference to in the house clearing video.
Okay. Are there any other matters we need to address today?
Not from the state's perspective, Your Honor.
Mr. Ward?
I don't believe so, Your Honor.
Okay, and I have this listed as a general denial. I didn't see any affirmative defenses filed in this instance. Is that correct, Mr. Horn?
That's correct, Your Honor.
Okay, and parties are ready to proceed with trial at 8:30 Wednesday morning next week. Is that correct?
That is correct.
That's correct, Your Honor.
You all have my love and attention for 3 days next week. We will see everyone here on Wednesday at, I generally will do counsel in chambers at 8:15 to discuss preliminary instruction matters and get some other matters rolling. Anything else before we break?
No, Judge.
No, Your Honor. Thank you for your time.
Thank you all. Have a good afternoon.
Too.
I think that she left so much up for trial day. We'll just figure that out during the trial. We'll just figure that out during the trial. I mean, I'm probably going to get the trial, but I probably won't show the trial. I feel like 3 days is going to be a long time. I think it's going to be boring. But what I might do for you guys is show closing statements and the verdict. Unless you guys want that trial. You guys just saw what it's going to be. If you want that trial, let me know. I'll show it. I'm fine showing it. I thought that was interesting. I thought it kind of sucks for her. I feel bad for her. I wish that she wouldn't have been charged with this. Oh no, John. That sucks. See, that's why I don't change my batteries. They're just too dangerous. Thank you so much for coming out today, guys. So really, really appreciate it. We did well this stream, so thank you. I'll see you in a couple hours, guys. Remember yesterday, was it yesterday? We did Judge Fish. And we had a guy who was back because I guess he like cursed out the judge or something. He's pro se. I have February 2nd. And I think it's the same guy, but I don't hear him cursing out the judge at all. But we're gonna watch that. No more ponytails. I was wondering about you. That's such a good name. What's wrong with ponytails? Because I'm a server, so I have to wear ponytails constantly. My hair is in a ponytail more than it's not, and it sucks. It gives you headaches and it hurts. But anyway, see you guys in a couple hours. We're gonna watch that. It's not the whole stream. It's only like 30 minutes. We're gonna watch that guy. Thanks for coming out, guys. See you in a few hours. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, her joy she can't hide.